Thank you so much, Professor Greenwood. It is an exciting moment at HLS for the study of law and democracy with the launching of the Election Law Clinic that you are so wonderfully guiding with Professor Nick Stephanopoulos, Professor Larry Lessig's impactful work in the area of law and democracy, the Equal Democracy Project at HLS, and the voting rights work of the Charles Hamilton Houston Institute. HLS certainly has become the place for addressing pressing issues of law and democracy. It is also fitting that we are hosting this panel on the future of the VRA, as you have received a very nice note from one of our alums reminding us of HLS's intimate connection to the VRA. Bert Wittes and Carrie Parker, class of 65, James Flood, class of 63, staffed the Senate fight to extend the VRA and to lower the national voting age to 18. In 1965, Mr. Wittes also staffed the Senate extension of preclearance for another 5 years and its dramatic extension. Stanley Pottinger, class of 65, also provided congressional testimony as head of the DOJ Civil Rights Division. And so HLS has had a long history on providing and creating the structure of the Voting Rights Act. And our distinguished panelists, all three of whom are HLS alums, continue in that tradition, each in their separate way. So let me briefly introduce them. Jessica Amundsen from Jenner and Block is a distinguished graduate of this law school. She's the co-chair of the firm's appellate and Supreme Court practice and chair of the firm's election law and redistricting practice. She was named in 2018 appellate MVP by Law 360, which recognizes the 5 attorneys in the country that had extraordinary wins and contributed most to their practice area in the past year. She's an experienced litigator, including before the Supreme Court, and argued the Brnovich DNC case. And we're so happy to have her here this afternoon. Sam Spatal, also distinguished Harvard Law grad, and a very distinguished civil rights attorney, director of litigation at LDF, the Legal Defense Fund, NAACP Legal Defense Fund, and Northwest Austin Municipal District Utility Number 1 versus Holder, as well as Shelby County versus Holder. Sam was an integral member of the LDF led teams that represented African-American voters who intervened to defend the constitutionality of the act. He has extensive practice in civil rights litigation, including successfully representing 3 men who served between 25 and 40 years in solitary confinement. And we're so happy and pleased to have him here as well. Mr. Bert Rhine, our third panelist, is again an HLS grad, a founding partner of a law firm that bears his name. He is widely recognized as a leading antitrust and commercial litigator and international law expert, has been recognized as a visionary and Washington's leading food and drug lawyer. He is here because of the role that he played in successfully representing Shelby County, Alabama, and its challenge to the constitutionality of the renewal of the preclearance provisions of the VRA that was argued before the Supreme Court. So I am so happy to have these 3 amazing individuals to discuss the Voting Rights Act and the future of the VRA. I'll start with Sam. Sam, if you wouldn't mind just setting the table for us and giving us an overview of the VRA, how it has worked, and why it's important.
Thank you very much. And let me start by thanking you, Professor Charles, for that introduction, and thanking you for inviting me to this conversation, which is so important, especially today, given the somewhat precarious state in which we find our democracy. I think that to talk about the Voting Rights Act, which has been recognized as the crown jewel of the civil rights movement, the most transformative of the civil rights statutes passed in the 1960s, you have to start by talking about what happened about 95 years before the Voting Rights Act of 1965, when Congress passed and the states ratified the 15th Amendment to the Constitution, which prohibits the denial or abridgment of the right to vote on account of race or color, and which provides to Congress the authority to enforce that prohibition through appropriate legislation. As the Supreme Court recognized in the Shelby County case, the first almost century of congressional enforcement can only be described as a failure, however. in the 1890s, states throughout the former Confederacy passed a whole wide range of laws that were designed to prevent Black people from voting in this country. Literacy tests, good character tests, knowledge tests, all of which were applied in a discriminatory way. And in addition to these laws, Black people seeking to register to vote in a number of southern states often face violence when they try to do so, and in some cases lost their lives. Congress responded very slowly. It finally began taking some steps to try to facilitate case-by-case litigation that would address this discrimination with some earlier civil rights laws in the 1950s. But the problem with these earlier laws was that case-by-case litigation was very slow, and frequently states and localities would circumvent a favorable judicial ruling that prohibited one type of voting discrimination by creating a new type of discrimination that was not covered technically by the four corners of a federal decree, and that case-by-case method was just not effective in actually opening up registration and opportunities for participation for Black people in much of the South. All of that changed with the Voting Rights Act of 1965, a law that was only possible because of the sacrifices and bravery of Black people throughout the South, and most particularly in Selma, Alabama, which at least temporarily awakened the nation's conscience and really provided an impetus for a more meaningful Voting Rights Act. And that's what happened with the Voting Rights Act of 1965. It has a number of features that make it so transformative, but I just want to focus on three that I think are especially relevant for our conversation today. The first is that the act broadly prohibited, initially on a temporary basis, but ultimately permanently, literacy tests, good character tests, all those tests and devices that have been used for so many years to prevent Black people from equally participating in the registration process even. And then it enacted two major sections, which continue to be the heart of the act today, and I think will be sort of the focus of much of our conversation. Section 5 of the act, known as the preclearance mechanism, was targeted to this problem of circumvention that I talked about just a few minutes ago. It required states and localities with particularly severe histories of voting discrimination to submit either to the Department of Justice or to a federal court changes in their voting laws and policies to ensure that they would not be discriminatory. So it prevented states and localities from doing what they had been doing, which is circumventing a prior judicial decree with a new type of discrimination. Section 5, as Professor Charles sort of noted when he was talking about some of the contributions of HLS alums, was a temporary provision, and it had to be reenacted. And every time that it came up for reauthorization, Congress did reauthorize it by overwhelming bipartisan margins, recognizing that preclearance was still necessary in parts of the country to prevent this resurgence of voter discrimination. Most recently, it was reauthorized in 2006 by a 98-0 margin in the Senate, 390-33 in the House, and signed into law by President George W. Bush. And I basically stop there. I'll just sort of note now that we are in we're sort of at the precipice about where we're going next with the Voting Rights Act because of the court's decision in Shelby County, which effectively invalidated Section 5, and because of the Brnovich decision, which has limited the reach of Section 2.
All right, that's perfect, because I'd like to bring Jesse in, who's an amazing Supreme Court litigator. Can you bring us up to Shelby County and Brnovich and help us to understand the role of the court in interpreting the act and essentially why we are where we are today with the VRA?
Thanks so much, Professor Charles. And I just want to say at the outset that I'm so delighted to be here with you and with Professor Greenwood, and just so excited about the new election law clinic at Harvard, something that I absolutely would have loved to participate in when I was a student. So So I'll try to briefly kind of sketch out 50 plus years worth of Supreme Court jurisprudence on the Voting Rights Act. As Sam said, the Voting Rights Act was really the crown jewel of the civil rights era. And perhaps unsurprisingly, the preclearance provisions that Sam outlined were immediately challenged by the southern states that were covered by them. And in a case called South Carolina versus Katzenbach in 1966, the Supreme Court, in an 8-1 decision, held that the act was a valid exercise of Congress's enforcement powers under the 15th Amendment. And the court made a finding that it was perfectly rational for Congress to have concluded that case-by-case litigation was inadequate to combat the widespread discrimination and obstructionist tactics that were used, and also found that it was perfectly permissible for Congress to limit its attention to the geographic areas where immediate action seemed most necessary. And in sort of the most kind of widely quoted line from that opinion, what the court found was that after enduring nearly a century of systematic resistance to the 15th Amendment, Congress might well decide to shift the advantage of time and inertia from the perpetrators of the evil to its victims. And so following that, there's kind of a series of cases in the 1970s that really are more about vote dilution. So Section 5 is kind of off doing its work, but then there's a series of cases challenging mostly at-large election systems. And in 1980, in a case called City of Mobile versus Bolden, the Supreme Court decides that Section 2 of the Act the protections of Section 2 are essentially coextensive with the protections of the 15th Amendment. And that's important because essentially the court had construed Section 2 of the Act to prohibit only intentional discrimination. And Congress then reacted in 1982 by amending the Act to make clear that Section 2 of the Act prohibits not just intentional discrimination, but it prohibits the application or enforcement of any kind of election law or procedure in a manner which results in the denial or abridgment of the right to vote on account of race or color. And Congress also kind of spells out exactly how a violation is established. And that is if based on the totality of circumstances, it's shown that the political processes leading to the nomination or election in a state are not equally open to participation by the protected class of citizens, or that they have less opportunity to elect candidates of their choice. And so this amended Section 2 is then construed by the Supreme Court in a case called Thornburg versus Jingles in 1986. And Justice Brennan's opinion for the court sets out sort of 3 threshold preconditions that a plaintiff has to satisfy to make out a Section 2 vote dilution claim. And then also kind of enshrines what was the legislative history of 1982 as the totality of circumstances inquiry by setting out these 9 Senate factors that courts should look to. And these include things like the history of official discrimination in a jurisdiction, the ongoing effects of that discrimination, and the state's justification for its procedures. And what the court says is really that the essence of a Section 2 claim is that a law or practice interacts with social and historical conditions to cause the inequality in opportunity between minority and non-minority voters. And so then for the next 25 years, the court kind of has this steady stream of Section 2 vote dilution cases, in some of which plaintiffs prevail, some of which plaintiffs lose, but even up until 2006, plaintiffs are continuing to prevail in Section 2 cases before the Supreme Court. And then as Sam noted, in 2006, Congress also votes to reauthorize the Voting Rights Act for another 25 years with sort of overwhelming bipartisan support. But then that is immediately challenged. And in a case called Namunno, Northwest Austin Municipal Utility District #1, if I'm getting it right, the pronunciation or the abbreviation. Chief Justice Roberts writes this decision. So Section 5 is challenged. Chief Justice Roberts writes a decision for an 8-1 decision. essentially saying that the court is not going to decide the constitutionality of Section 5 and is instead going to decide the case on statutory grounds using constitutional avoidance criteria. But there is lots of dicta in the opinion kind of talking about the issues about the fact that the coverage formula by which states become subject to the Section 5 preclearance regime is outdated and fails to account for current political conditions. So, I know we'll be hearing in a bit about the Shelby County decision, but that sort of takes us up to Shelby County, when then the Section 5 preclearance regime is again challenged, and the court says that because Congress has not sort of reacted in the interim between the 2006 Namundo decision and 2013 to kind of update the coverage formula, the court is left with no choice but to strike it down. And because that the court finds that it's because the coverage formula does not account for current conditions, and that it denies kind of equal sovereignty of the states under the 10th Amendment. And that, of course, is the decision in which Justice Ginsburg pens her famous dissent that kind of launches her career as the notorious RBG, in which she says that throwing away the preclearance regime that is working and in stopping discrimination from happening is like throwing away your umbrella in a rainstorm because you're not getting wet. And so now that Section 5 is gone, sort of all of these state laws that had previously been stopped by the preclearance regime go into effect. So literally within 24 hours of the Shelby County decision, Texas enacts its new strict photo ID law. Mississippi and Alabama reintroduce photo ID laws. North Carolina begins to act to cut back early voting and cut back on various registration procedures, et cetera, in a way that a Court of Appeals finds kind of acted with surgical precision to target the practices that were most relied on by minority voters. And so plaintiffs now have to, whereas before the burden was on states to come forward and show that their practices were not discriminatory, the burden is now on plaintiffs to go to court to challenge these practices under Section 2. And these are called sort of vote denial claims under Section 2, which are separate from the vote dilution claims. These make a variety of these cases make their way through the courts of appeals. Some of which plaintiffs prevail, some of which plaintiffs lose, and eventually the court takes the Brnovich decision the Brnovich case, which it decided earlier this year, that I argued on behalf of the Arizona Secretary of State. And there were two Arizona laws that were sort of at issue in that case, but what was really at issue in that case was the test that the court was going to apply to these vote denial claims, because the court had had sort of years of vote dilution claims, but had never taken one of these vote denial claims. And what the court says is, this is our first foray into the area, so we're not going to set out a definitive test. However, here are 5 guideposts that courts should look to for purposes of determining whether there's a violation of Section 2 when a plaintiff is challenging a facially neutral law that results in a disparate burden on minority rights to vote. 4 of those guideposts are things that lower courts had sort of been doing in the past. One of those guideposts is something that Justice Alito, who wrote the opinion for the 6-3 court, essentially offered up for the first time at oral argument and then later enshrined in his opinion, which is pegging the burdens of voting to what existed in 1982 when the Voting Rights Act was amended. I'll just finish by saying, kind of being on the losing end of that decision, I'll say 2 kind of bright spots I take away from that decision are that it is not a Namundo type decision. There was lots of briefing and lots in the background of people worrying about the court sort of calling into question the constitutionality of Section 2 of the Voting Rights Act. There's sort of nothing about the constitutionality in the court's opinion. And then the second thing is that the opinion does sort of reaffirm that Jingles is the court's seminal vote dilution case. And so there is some kind of reaffirmation of the Jingles vote dilution framework, which I take to be important, particularly as we go into this new round of redistricting litigation. So I think that brings us up to today.
Okay, this is great. I want to come back in a moment to your optimism about Brnovich and ask about it. But let me first turn to Bert, and before doing that, just to frame for us where we are, right? So you both have helped us to understand how the 65 Voting Rights Act is a response to a series of discriminatory behavior, particularly by states in the South who were unrelenting since the end of Reconstruction and denying particularly Black people, but not just Black people, the right to vote, and how Congress responded to that by creating a regime of supervision of those states. And then Section 2, amended in 1982, to also address not just vote denial, but also vote dilution claims. So that way we're dealing with a system in which Congress targeted particular states that they have to pre-clear, but also providing plaintiffs the opportunity to challenge sets of voting practices as well as electoral structures to assure that voters not just have the right to vote, but also right to adequate representation. All right, now that takes us from 1965 to basically 2013, but even through the Brnovich case, in which seemed to have a shift of regime where the court seemed to be supportive of the VRA, but certainly in the last few years, indicated by Namudno, but also certainly by Shelby County, of a court that certainly seems to be hostile to certain parts of the VRA. So now I want to turn to Bert and your role in the Shelby County case. So can you first tell us why you thought that Section 5, the preclearance provision, the coverage preclearance formula, that whole tandem is unconstitutional, and how are you reacting, and what do you think of the claims that Shelby County, the court's decision in Shelby County, has had a detrimental impact on voting rights and has made it harder for people to exercise their right to vote free from racial discrimination? We can't hear you yet.
I'm unmuted.
All right.
Okay, thank you very much, Professor Charles. I'm delighted to be invited to this garden party, even if I'm the skunk in the party and the black sheep of the Harvard Law School.
You're not at all the skunk. You're a full participatory member.
Yeah, and let me just say that, just to be clear, because I think we're all lawyers and we need to say this, I represented and argued for Shelby County. It's representation of a client. So what I'm going to say is, in large part, the views of the client, which from my point of view raises a question: do they have a fair cause to put before the courts? Is there a respectable position, and should it be advanced? And I think we all need to recognize that as lawyers, we're occasionally called upon to take controversial cases. If there's a fair legal basis for them and no reason to step away from them, particularly in a normal engagement, I think we have a duty to advance those causes and let the courts decide. So having said that, let me explain at least the motivations of our clients with respect to why to challenge Section 4, the formula basically, and Section 5, the preclearance provision of the Voting Rights Act. And I'll say that, of course, the case did not involve any challenge to Section 2 of the Act, which is the provision under which a lot of litigation has been started. And Section 2, and we shouldn't mistake this, was absolutely critical to the overall structure. Because while Section 5 essentially was kind of a prevention of whack-a-mole, where the state would move and shift in order to avoid Section 2, it did not take apart pre-existing practices. And therefore, you envision an act which allows Section 2 to operate against discriminatory practices and Section 5 to avoid the recurrence of those practices under a slightly different guise. So Section 2 has an independent significance. There's also a Section 3 to the Voting Rights Act, which allows litigation, including as a remedy in litigation, judicial decrees that separately subject to jurisdiction that's been found judicially in violation to preclearance, independent of Section 5. So that gives it a little bit that, that Section 5, because it's now become, essentially a spotlight for people's concerns, may not really be viewed in isolation. It's part of an integrated act. And I think the question in the broadest sense is whether when individual practices are challenged, are states really resorting to whack-a-mole? If you looked at the record in Shelby, I think that Section 5, whether it's the prophylactic effect of the section or the actions thereunder, and it had an effect on states' flexible responses to discrimination. The number of instances in which preclearance was denied was minimal with respect to the overall burden of the act, the filing of every small change with the Department of Justice. So, I think what the court was reacting to was, maybe this problem is not as severe today being 2013, as it was in 1965, when the country was really confronting overall the remnants of Jim Crow and trying to eliminate it. So I say that as contextual. So why was the case brought? First of all, what was the motivation? For Shelby County, one of the big motivations was cost, because every time they made an electoral change, none of which had ever been denied preclearance at the county level, they had to file it. And it was costing a fair amount of money from a county budget. So one of the impetuses was, we don't need to bear this cost. We're not really in a position to be looked at that closely. The second impetus was effectively considerations of federalism, because state officials don't like to be under the federal mandate. They always had, and constitutionally do have, the right to regulate their elections unless they are shown to have transgressed the bounds of the 15th Amendment. And I think a strong feeling from many of the people who favored the case was, well, we had to deal with an emergency. That's what Katzenbach was justified by. And it's time we went back to a more traditional constitutional framework in which cases have to be proved before the remedy is invoked. So, I think that kind of explains what drove it from the point of view of why bring it, why challenge. The second consideration was essentially looking at the strategy of litigation. The Nomudno case, which has been discussed, made very clear that there was real trepidation in the court about at least the formula, which singled out states and jurisdictions for preclearance. And that was an 8-1 decision in which all joined in questioning the formula. And therefore, it seemed to us, from a kind of lawyer's point of view, the court would be receptive, the Supreme Court at least, to another challenge which emphasized the points that have been raised in Nomudno. They ducked Nomudno, but I think essentially we could structure a case in which they couldn't duck it, because Shelby County was subject to preclearance only because one of its one of its sub-jurisdictions, the city of Caldera, had a single violation which precluded it from, quote, bailing out. Bailing out was a remedy available under the act. If you behaved for an extended period of time, 10 years, you could get out of preclearance by showing that you'd become good. I'm just starting loosely, but preclearance was what drove Nomudno. That was the statutory issue. Could that jurisdiction have one way or another opted out? And since that was not decided below, the case was sent back and it was ducked. And Shelby County couldn't be ducked because it was directly affected. It could not bail out. So it squarely presented the issue. And in addition to that, the composition of the Supreme Court had changed. Justice Kennedy had retired. He was replaced by Gorsuch. And therefore, there seemed to be a reasonable prospect that the court would significantly reconsider its position. So that's why the case was brought, and actually it involved two fundamental constitutional claims, one of which went directly at the formula. The fact that the statistics used to designate the states were the 1972 election statistics had never been updated, and Congress had really shown no disposition to inquire into the the formula itself. So that struck us as something the court might be concerned about, had been concerned about. The second issue raised in the case, which was not decided because it was unnecessary, went back to Katzenbach. And the question there was, to what extent does the 15th Amendment justify the imposition of substantive rules and federal supervision on the powers of the states to regulate election? How extraordinary is it? What circumstances would justify it, and whether they still existed? It was briefed throughout the case, but the court did not reach it because the case was disposed of on the basis of the formula, and with absent the formula, there was no effect to Section 5. It may sit as a mechanism, but it's not effective because it doesn't apply to anybody. And put the challenge to the Congress. You might want to inquire in this again and see, if you want preclearance, where circumstances would justify it. I don't think the court necessarily endorsed any updated formula. The question was, what would the formula be, and what would be the evidence behind the formula? So I hope that explains why the case was brought, what prompted us to bring it, and obviously we're right in thinking the court was about to change its mind. And I'll just say the second question, the circumstances that justify this extraordinary federal intervention, as it was labeled in Katzenbach, are not defined at this point and would raise important questions with respect to any new formula that Congress chose to enact. And we'd have to wait and see what that formula meant and how the evidence behind it and the specifications for preclearance would be viewed by the court. If you go back to Katzenbach, the vote was 8-1. The vote was unanimous with respect to all the provisions of the Voting Rights Act except the preclearance. And there, Justice Black wrote a dissent saying that's too much. It's essentially undoing a key element of the federal system, which is local control of election qualifications and procedures. So I hope that explains where the case came from and where we think the case came out.
Thank you. That's very helpful. So I want to think about the future of the VRA, particularly the John Lewis Act. But in order to do so, I think we have to come to terms with something that you said, Bert, and which I also goes to a point that I raised with Jesse. How optimistic can we be about the remaining provisions of the VRA, as well as how optimistic can we be, assuming that we can get that Congress can get something through on the John Lewis Act, how the Supreme Court might look at a new coverage formula. And the central claim, and the one that Bert put on the table that I want us to think about, is the idea from Shelby County that the circumstances that gave rise to the structure of the VRA and the idea that the VRA is an extraordinary remedy, those set of circumstances no longer exist, that this is not the world of Jim Crow, that this is very different. And then that raises questions about Section 2 of the VRA, both dilution and right to vote, a disparate impact in particular. It raises questions about the possibility of a new formula. So let me turn it to the both of you for a moment to help us to think about this idea that, look, the circumstances are very different, right? And this is not 1965. It certainly is not the turn of the 20th century. People can vote without any racial restrictions. We don't have, sheriffs driving using water hoses to preventing people from voting. So how do you respond? And therefore, we can't justify the VRA framework. How do you both think about this? First, I'll turn to you, Sam, and then to you, Jesse.
Thank you. So, yeah, I do think that is one of the central questions that was clearly animating the court's perspective. And Chief Justice Roberts famously promised us in Shelby County, the South has changed. You don't have to worry so much anymore. I think that prediction was unjustified by the record that was actually before the court in Shelby County, which showed that whatever progress had been made in the previous 25 years prior to the previous reauthorization, there had been over 600 examples of discriminatory voting laws that were blocked by Section 5, 2/3 of which had evidence of discriminatory purpose, and then another 600 voting laws in the jurisdictions covered by Section 5 that were blocked by Section 2. So there was a robust evidentiary record that there was still this need for both Section 5 and Section 2. And the evidence also, from our perspective, showed this persistent problem of circumvention. And so, as Mr. Ryan noted, one of the reasons why Shelby County was, in a sense, the right plaintiff was that there is a provision under the Voting Rights Act, a statutory provision designed to ensure that jurisdictions with clean records, so to speak, which don't have a persisting problem of voter discrimination, are able to bail out. Don't have to bring a facial constitutional challenge. There's a provision within the statute. The reason why Shelby County was unable to do that was that one of its cities, the city of Calera, had a Section 5 objection because it had engaged in over 100 annexations and had done a redistricting without obtaining Section 5 approval. And if you drill down a little bit more closely, what you saw was that what that was about was that there had been a previous judicial decree that the city of Calera had a discriminatory method of election that essentially prevented Black voters from electing candidates of choice, which had been invalidated as part of a famous series of cases in Alabama in the late 80s and early 90s, the Diller litigation. And these new measures that the city put in place were designed to circumvent that judgment and essentially recreate a method of election that would, again, deny Black voters an opportunity to elect candidates of choice. So from our perspective, the record was in fact quite robust in the Shelby County case. And since Shelby County, as Jesse sort of alluded to, I think it is difficult for anyone to continue to take the perspective that voting discrimination is not a serious problem in this country. It is clearly a serious problem in this country. You saw that with the wave of measures that were immediately implemented by formerly covered states and localities in response to Section 5, where they were just waiting or they immediately re-implemented new discriminatory measures. And in many cases, federal courts later found that they included measures that were surgically targeted, as Jesse alluded to, or similar language that were really designed to go after methods of voting that were particularly used by Black voters and other voters of color. And in the voter ID context, for example, you have situations where it's not simply that the state has enacted a voter ID, but that the state will allow gun licenses, but not student IDs, would not allow public assistance IDs, forms of IDs that were known to be more likely to be used by Black voters were not possible forms of identification that were more likely to be possessed by Black voters were not considered valid. And particularly now in the wake of the 2020 election and this new wave of voter suppression in a number of, in particular, although certainly not limited to formerly covered jurisdictions, the problem, the persistence, the adaptive nature, and the metastasization of voting discrimination from my perspective is quite clear and speaks powerfully to the need for very vigorous federal legislation to address it.
Thank you. Jesse, I'll ask a similar question, but pose it very differently. So this is something also that Bert put on the table, which is, look, the one way of interpreting the current constitutional framework is that, look, if people are engaged in racial discrimination, we now have a vigorous enforcement of the 14th and 15th Amendments. When the Voting Rights Act was passed, a number of Southern courts, including some federal judges, would not enforce the 14th and 15th Amendments, And that is no longer the case today. So if there is some racial discrimination, the constitutional framework can respond to it. We don't need the special provisions of Section 4, Section 5, and we certainly don't need the vote dilution provisions of Section 2, which arguably seem to go much farther than is required by the Constitution, unless justified by blatant, structural, pervasive racial discrimination. How do you respond to that type of a claim? And then, Bert, we'll give you a chance to jump in, and then after that, we'll just spend the rest of the time answering the questions that a number of the audience has posed. Please continue to send your questions in.
Thanks. So, I think, as the court did actually say in Shelby County, voting discrimination still exists. No one doubts that. So I think that some of the issues that Mr. Ryan was discussing about the fact that that preclearance submissions were overwhelmingly approved. What one has to remember is that Section 5 also had a very strong deterrent effect, such that states would not submit laws that they knew would not be pre-cleared by the Department of Justice or by the federal court. And so you see that in the fact that essentially after the Shelby County decision, the Mississippi and Alabama, for example, revive photo ID laws that actually were never submitted for preclearance because they knew that they would not have been approved. So in addition to kind of what happened in the wake of Shelby County, you also now have what has happened sort of in the wake of the 2020 election, where you see the states in which minority turnout has increased the most are also the states in which state legislatures are imposing new restrictions on the right to vote. And so, I think that while Section 2, and I guess I should clarify also to your earlier characterization of my comments, Professor Charles, is that I'm not overwhelmingly optimistic about robust enforcement of the Voting Rights Act. Although I did take away from that decision at least that the court did not have sort of a whole section kind of sort of previewing the coming demise of the constitutionality of Section 2 in the way that the Namuno seemed to preview the coming demise of the constitutionality of at least the formula, if not the preclearance provision itself. But Section 2 puts the burden on the plaintiffs to come forward and to prove a violation, and of course the Brnovich case now makes that more difficult. But it's a game of sort of whack-a-mole again, as states sort of enact these new restrictions on the right to vote that are importantly kind of not justified by any legitimate state interest. And this is sort of another kind of theme that I think is important to bring out, is that where these restrictions are being imposed, the legislatures simply kind of invoke election integrity or the prevention of voter fraud, yet there is literally no evidence ever in the record, nor are legislatures required to put into the record any evidence that such fraud actually exists, or that the provisions that they are attempting to enact are in any way kind of, if not narrowly tailored, at least even sort of related to preventing the type of fraud that they are that they fear. So that is where we find ourselves. And as I said, I'm not overly optimistic, but at least we don't have kind of the constitutionality of Section 2 immediately teed up right now.
Great, thank you, Bert. Before we go to questions, so how do you respond to the claim that, look, many states are targeting voters of color? And not only are these electoral rules targeting voters of color, there's also no legitimate state justification for doing so. And so the underlying claim that the framework of the VRA is no longer justified by history is undermined by current realities. And so we still need the framework of the VRA, whether it's a renewed preclearance coverage formula or continued robust enforcement of Section 2's dilution and right to vote interpretation.
Thank you. I just make a comment on the record. Yes, there were instances of denials of preclearance, but if you look at the record, they were diminishing, and in the years immediately prior to the reenactment of the extension of the VRA, they were really negligible. So you were putting on an enormous administrative burden with respect to a very small number of cases. I mean, the central issue is whether circumstances require something more than case-by-case intervention, whether the traditional constitutional framework is you challenge something when it affects you and you prove that it is contrary to the safeguards of the 15th Amendment is sufficient or insufficient. If you look at the measures that were in Congress originally put in effect for the formula, you're looking at devices, most of which are now banned and really aren't an issue anymore, literacy tests and the like. And you're looking at turnout, which is quite different registration and turnout. So now we have more selective examples. Just one observation is the first case that reached the Supreme Court with respect to voter ID came from Indiana, a state which was never affected by Section 5. And there are controversies in Ohio and North Dakota all over the place, which the pre-existing formula would never have reached and kind of insulated themselves for 25 years. So I don't think you see that same kind of concentration of the issue in the South. And also, it's now all kind of mixed up with partisanship, because you can look at this as, well, who are the voters that are disadvantaged? But those same voters tend to move in one direction politically. And I think that's, essentially pushes toward some of these measures in situations where, per se, race discrimination or discrimination on national origin is not as much of an issue. And ultimately, I think we all know that demographics rule. And if you can't stop people from voting, they may have to try harder. They may have to do what was done in Georgia and put in a lot of effort into it. That is going to change. And I think that with the number of minority voters today, that's a constituency you can't ignore. So the question becomes, do we turn over the constitutional federalism order and go beyond case-by-case litigation? I think that's where the court's going to wrestle with the issue in light of whatever specific formula anybody tries to enact. As I say, the case that Shelby did not involve Section 2 and the flexibility with which challenges should be made. And the last thing, just an observation, under preclearance, a great deal depends on who's the Attorney General. And I think that even those who are advocates of preclearance might have looked at it quite differently in the Trump administration as they did in the Johnson administration of 1965, because I'm not sure that any of the measures that people are really concerned about would have been denied preclearance when Jeff Sessions was Attorney General, or even Bill Barr. That was probably not going to happen. So I think that anything that depends on that politic may not be as effective as people think it will be. And you can witness in the Congress today, there's resistance to all of the acts that are coming up. And I think a lot of that resistance is just partisan. These voters are viewed as Democratic voters, voting in mass, not issue by issue. And part of the polarization of the country is reflected in the way that people seek advantage in the electoral process.
This is very useful. So I'm going to now turn to questions, and I'm going to just pose one question to each of you from the audience. Also a reminder that Harvard faculty, Professor Charles Freed, argued jingles in the Supreme Court and really was instrumental. Professor Lawrence Tribe, and of course, Professor Lonnie Grenier at Harvard has contributed significantly. So I wanted to shout out to those folks as well. All right, Sam, here's a question for you, which is, whether Section 5 would have prevented the passage of the new Georgia law on voting through preclearance. And then, Jesse, one question for you, which is, why can't a voting rights bill be passed to exist in perpetuity? Why does it have to keep being renewed? So just some clarification on the mechanisms of the VRA, and then can we pass a voting rights bill that doesn't require renewal? And then, Bert, one from you, from a 64 classmate: is the rest of the VRA vulnerable to your analysis of Shelby County and its progeny? And if so, how? All right, so Sam, and if you could just try to be as brief as you can, I'd appreciate it, everybody.
So the brief answer is yes. I think that it's pretty clear Section 5 would have prevented Georgia's law, because Section 5 categorically prevented laws that put voters of color in a worse position with respect to the exercise of the franchise than they were before. And just I'll very briefly add that I think this does get to some of the issues that Mr. Ryan just raised with admirable candor, sort of about, his perspective on where we are and where the court is and where the country is. But one of the things that I think is particularly troubling, I guess I would sort of argue the flip side in a way of what he said, is the previous consensus that I think we as a nation had, that the right to vote was sacred and should not be, that no voter should be denied the franchise or have to wait in a much longer line, as Black voters in Georgia do, than non-Black voters, in order to exercise the fundamental right to vote, and that there is no partisan justification and no, sort of electoral advantage justification that could override that basic principle. And I think one of the things that has been most damaging about where the country has gone in the last 10 years or so has been that consensus is no longer in place.
Thank you. Jesse.
The answer is also yes, that there are things that Congress could do on a permanent basis. The reason that the Voting Rights Act needed to be reauthorized regularly was that the preclearance formula, as the court then later elaborated in Shelby County, was supposed to be tied to current conditions of discrimination in voting. And so, I think that this will certainly be an issue for purposes of the legislation that is currently pending in Congress, and will also raise the issue that Mr. Ryan was talking about earlier, that Congress, or that the court kind of ducked in Shelby County, about whether an enactment by Congress needs to be congruent and proportional under the 14th Amendment, or whether the 15th Amendment rationality standard from Katzenbach will apply. But certainly there's hope that Congress can do more to protect voting rights in the future.
Bird, a question from your classmate.
Always happy to answer to my classmates. I think that the permanent nature of Section 2, the fact that it can continue, the permanent nature of the 15th Amendment says, yes, you could pass certain voting rights provisions which don't challenge the constitutional federalism order and make them permanent. The reason that for reauthorization was first take another look at the formula and also drive a political consensus, but also because you are dealing with, as Katzenbach indicated, an extraordinary departure from the basic constitutional framework of division of powers or separation of powers between the states and the federal government. And that is not, at least with this court, going to be taken lightly. And so they're going to look hard at the question, when does that basic order need to be disrupted? Is the situation so important that the enforcement role of the Congress has to be more direct? That's going to be the issue in anything that goes back to preclearance. I don't think Section 2 is at that same junction of risk. It's a much more traditional way to enforce constitutional rights. You bring your case in court, you prove your case, and then there's a remedy of either enjoining something, or under Section 3, indeed, of placing an injunction in place that's more remedial, where the court reviews all your changes. So I guess the answer to that is there is going to be some risk to every piece of legislation. Somebody's going to argue it. I think that if you really think, kind of a hypothetically, the way Harvard likes to think, you could envision a situation where you have a conservative president and attorney general, you have a black majority in some state, which passes on a state level some of the more expansive voting rights laws that people want to have in place. And then it gets attacked by white voters who say, this dilutes my vote unfairly. We're having all kinds of unqualified people voting. I'm not getting the full weight of my vote. What would that look like in a preclearance if you imagine a very different kind of federal administration? So, if you go back to the circumstances of 1965, it's not just the situation, it's the politics behind it and the effectiveness of the remedy. Just a bunch of interesting questions. So I'm just raising them. I think it's fair to think about them.
All right, one last question for the panel. What should the future of the VRA of voting rights look like? Theoretically, so one basis for the discussion here is that there's a division of authority between the states and the federal government. And in some respects, when we talk about federal elections, doesn't Congress have a broader role to play in protecting federal elections from both race discrimination and other types of discrimination? So if you were Czarina or Czar of the world, how would you do voting rights policy going into the future? Bert, let me start with you. I'll go to Sam, and then I'll end with Jesse.
Well, that was the hardest question. So
we have 2 to 3 minutes.
Okay, real quick. I mean, I think that there ought to be a remedy to enforce the provisions of the 15th Amendment. I think that this court is going to say that remedy has to be on a traditional basis where you prove your case by case, and that, in a sense, having broken the fever of Jim Crow, it's not going to come back in its old sense. We'll still have partisan maneuvering. I mean, I live in a state, Maryland, we were totally gerrymandered. My vote has pretty much been diluted, at least at the House Representative level, in order to create a pure Democratic representation in court. This is going to happen. You can't eliminate people using and trying to manipulate voting procedures for partisan advantage. And so I think we'll have continuing tussles. I'm not sure that we're going to have a reinstitution of the pre-1965 order.
Okay. Dan.
So I'm going to punt the question to talk about what Congress is actually doing, which I think is sort of at least indirectly responsive, which is Congress has 2 bills that it could well enact. One is a Voting Rights Restoration Act, now named after the great John Lewis, which does create a new formula that is plainly updated to current conditions because it looks to whether or not a state or locality has a certain number of voting rights violations over a recent period. It wouldn't have to be limited to jurisdictions in the South. It'll sort of go for sure wherever the discrimination is happening. And the reason why, from my perspective, some remedy like preclearance remains essential is that we have seen what has happened without it. And even in places where this slow case-by-case method has ultimately led to some relief, especially at the statewide level, where it is at least easier for civil rights organizations to sort of track what's happening, it is years often that the prior discriminatory measure is in place. And during that period of time, hundreds of thousands or millions of voters are having their votes denied or abridged. So I just don't think this is an area where you can rely solely on case-by-case enforcement. I think as just a matter of facts on the ground, that is not possible. And then very briefly, the other key bill before Congress right now, the Freedom to Vote Act, actually would address Mr. Ryan's concern. It would ban partisan gerrymandering. It has a whole host of other measures designed to make voting easier, making elections a national holiday, making sure people can do early voting, can do mail-in voting. And to your earlier sort of premise, Professor Charles, it's all based on Congress's broad authority under the Elections Clause to regulate federal elections. So it has a number of those measures that I think are also very essential.
Jesse, I'm going to give you the very brief last word.
I would say only that Congress has and should have a role to play under both the 14th and 15th Amendment, as well as its Elections Clause power. And if I were Czarina, what I would require of state legislatures is when they are enacting legislation to restrict or limit the right to vote, they should actually have to prove why those restrictions are necessary. In the same way that when one is trying to enact campaign finance restrictions, one has to prove that those restrictions are necessary in court. And so I would have at least the courts protect the right to vote in elections, provide that at least the same level of protection that they provide to the right to spend money in elections.
Perfect. Thank you so very much for joining us this afternoon. We're so very happy to have you. Please you could learn more and support the work of the Election Law Clinic and all that is going on at Harvard. You have our undying gratitude. Thank you to all, and be well.